This is Barry Zalma on insurance. Today I'd like to speak about why it is fatal to your claim to lie to your insurer, because if you do so, and they find out, you will lose everything. False swearing is a special category of misrepresentation or concealment because it is made under oath. In criminal law, false swearing is called perjury. If there was any false swearing as to the property that was the subject of the insurance, it vitiated that policy. If there was false swearing as to the meat and corn, it vitiated the policy taken out upon those articles. The instruction, in effect, told the jury that if they believed there was false swearing with respect to the meat and corn in a claim based upon the loss of meat and corn, the result would be to vitiate the policy and that the plaintiff would not be entitled to recover the policy benefits. This was the decision of the Virginia Supreme Court in 1906 in a case called Williams versus Virginia State Insurance Company. In order for a false swearing to void an insurance policy, the false swearing must have been willful, made with respect to a material matter, and made with the intent to deceive the insurer. Where an insurance policy provides that an insured's concealment, misrepresentation, fraud, or false swearing voids the policy, the insured must have actually intended to defraud the insurer. Therefore, under Michigan law, for example, fraud must be proved by clear and convincing evidence, even when raised as an affirmative defense. Therefore, under Michigan law, the insured's intent in making a misrepresentation in a proof of loss is a material fact because it is falsely sworn and therefore voids coverage. Mississippi has a different understanding when there is more than one part to an insurance policy. A policy insuring various items and fixing the amount of insurance to be paid on each is separable, although the premium is fixed as an entirety, and that because the policy is void as to one item, that fact does not render it unenforceable as to the others. On the other hand, in Michigan, even when viewed in a light most favorable to the plaintiff, the evidence presented the trial court established that the plaintiff's claim for no-fault benefits were based upon fraud and false swearing. Reasonable minds could not differ that the plaintiff engaged in fraud for the purpose of recovering no-fault benefits. Because she did so, Farm Bureau, her insurer, had the contractual right to void the policy and deny her no-fault benefits. Under Oklahoma law, an insurer claimed that the insured violated a fraud and false swearing provision in an insurance policy must prove it by a fair preponderance of the evidence, not clear and convincing evidence required in other states. A concealment and fraud provision of an insurance policy makes clear that the general rule of insurance law requiring good faith and fair dealing applies to fraudulent statements and false swearing made by an insured after a loss. This provision is breached if an insured tenders a fraudulent proof of loss as the basis for recovery under the policy. In Mutual of Unum versus Cox, the Washington Supreme Court in 1988 was asked to interpret a homeowner's policy that stated the entire policy would be void if there has been fraud or false swearing. even though the insured's fraud involved only his unscheduled personal property. The court held that the entire policy was void, and the insured was not entitled to any recovery. This appears to be the majority position, that one cannot commit a little fraud, any more than one can be a little dead. An insured's ulterior motive in misrepresenting material facts to the insurer is irrelevant in determining whether a fraud and concealment provision provides a defense to an insured's claim. In the following case, the insured presented a fraudulent vandalism claim for damage caused intentionally by her son. The insured felt compelled to lie, as she had been threatened with physical injury by her son, who had a previous conviction for violent behavior and who had caused the damage. The California Court of Appeal stated in finding for the insurer because of false swearing, quote, "First, plaintiff admits that she knew she was lying to the defendant and did so with the intent that defendant not find out the actual fraud facts. Second, under Claflin, the intent to defraud the insurer is necessarily implied when the misrepresentation is material and the insured willfully makes it with knowledge of its falsity. Thus, plaintiff's intent to deceive was established as a matter of law." This is a case called Cummings versus Farmers Insurance Exchange, a 1988 decision of the California Court of Appeal. This conclusion is in no way avoided by the plaintiff's contention that the motivation for the false statements was her very reasonable fear of her son. As expressed by the U.S. Supreme Court in Claflin, an insured's ulterior motive in misrepresenting material facts to the insurer is irrelevant. In the context of the Cummings case, the plaintiff's motive of fear of her son's violence was irrelevant to the question of whether she intended to deceive the insurer. If Mrs. Cummings' son was her spouse or an insured of the policy, she may have recovered half of the loss had she not lied about the actions of the insured who caused the damage. It is not fraud to negligently damage property and admit your negligence. It is also not fraud if, in a fit of insanity, an insured destroys the property and, with the aid of pharmaceuticals, comes back into control and admits what was done while incompetent. It is the lie that gets the insured into trouble with Special Investigative Unit investigators and the courts. In Texas and Oklahoma, false swearing is explained this way, quote, "Where an insured knowingly and willfully overestimates the value of property destroyed or damaged, the policy is voided, and the insured's right to recover is defeated." The Mississippi Supreme Court explained the reason for the false swearing defense was that it would be unjust to allow a claimant to misrepresent facts which might lead to a valid defense, and then allow him to escape the consequences of the falsehood simply because he had succeeded so well that the company was unable to establish the defense. In North Carolina, the Court of Appeal recognized that, quote, "It is a basic principle of insurance law that the insurer may avoid his obligation under the insurance contract by showing that the insured made representations in his application that were material and false. Misrepresentations on an insurance application are material if the knowledge or ignorance of it would naturally influence the judgment of the insurer in making the contract and accepting the risk. In order to avoid a policy pursuant to state statutes, the defendant must show that the insured made statements that were 1, false, 2, knowingly made, and made in accordance with the decisions of the North Carolina Courts of Appeal. False swearing is a crime in all states if it amounts to perjury. If it does not amount to perjury, it is still a defense to a false claim. To establish that an insured intended to deceive an insurer under Missouri law, the insurer must show that the insured knew the representation was false, or did not know whether the representation was true or false, and 2, intended the insurer to rely on the representation. In Young v. Allstate, an Eighth Circuit decision from 2014, the Eighth Circuit concluded that during an examination under oath, the Youngs admitted that the initial inventory listed many items that were not damaged or destroyed in their fire. They gave various explanations for the discrepancies. The Youngs both denied that they had intentionally overstated the claim to Allstate. The district court granted summary judgment for Allstate on the ground that the Youngs, by signing the initial inventory, were deemed to have knowledge of its contents, and that no reasonable juror could conclude that the Youngs did not materially misrepresent their property claim. An insurer can assert false swearing as an affirmative defense to an action brought by an insured. To constitute such a defense, the false statement must have been made under oath with the knowledge that it was false, and with the intent that the person to whom the statement is made will rely on it. Actual reliance is not necessary, as actual reliance would be necessary to prove the tort of fraud. In Parasco v. Pacific Indemnity, a 1996 decision of the District Court in Pennsylvania, false swearing was important where the insurer suspected arson and denied the insured's fire claim. Although the insurer could not prove arson by the insured's, there was a legitimate question as to whether the fire was incendiary in nature. The insurer also had clear proof of misrepresentations made by the insureds under oath regarding, among other things, their active attempt to sell the property at the time of the fire. The court held that the materiality of false statements is to be determined at the time of the investigation. The court further held that the insurer's investigation into the insured's possible motive to commit arson was entirely reasonable and prudent, and inquiries into the insured's financial condition were therefore material to the issue of motive. As both the proof of loss and the testimony at examination under oath are sworn to by the insured, any material falsehood is sufficient to establish the defense of false swearing. The same is true of any difference between the facts testified to during the examination under oath or stated in the proof of loss and the facts developed from an audit of the insured's books and records or the insurer's investigation. The U.S. Supreme Court stated the rule in Claflin v. Commonwealth Insurance Company, a 1884 decision that has remained unchanged in the law, and it stated, quote, "A false answer as to any matter of fact material to the inquiry, knowingly and willfully made, with an intent to deceive the insurer would be fraudulent. If it accomplished its result, it would be a fraud effected. If it failed, it would be a fraud attempted. No one can be permitted to say, in respect to his own statements upon a material matter, that he did not expect to be believed. Their materiality in the eye of the law consists in their tendency to influence the conduct of the party who has an interest in them and to whom they are addressed. In my opinion, and that of just about every court that's ever discussed it, insurance is a business of utmost good faith. That means neither party to the contract of insurance may do anything to deprive the other of the benefits of the contract. Therefore, when an insured lies to the insurer to convince it to insure, or to convince it to pay more than it is owed, he or she breaches the covenant of good faith and fair dealing, and under the terms of the contract of insurance voids the coverage. It's just not nice to lie to your insurer. It is fatal to any claim to lie to your insurance company. So my only recommendation to a person insured is never lie. And my only recommendation to an insurer is, when you are lied to, void the coverage and refuse to pay. This video was adapted from my book, Zelma on Insurance Claims, Part 110, second edition, which is available as a Kindle book and a paperback from Amazon.com. If you found this video to be useful or interesting to you or your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, and click on the like or the Rumble button as you do. And to my podcast, Zelma on Insurance, to my blog, and to my Substack publications, and to my community on locals.com. Thank you for your attention.